closing. All right? We're giving up, even though we haven't been paid, I'm the seller, we're giving up possession. And if, in fact, this buyer defaults, I'm not going to say there's no easy way for the seller to get it back, but there is no easy way for the seller to get it back. Okay? In some states, most of the states that surround us, if a buyer defaults, the seller can simply send a notice of forfeiture to the buyer and evict them, and it's over. We aren't even close to that in this state. If the buyer defaults, you've essentially got three routes you can go. And it's going to be, when you're talking with sellers about selling a land contract, they need to have some sense of what's available to them if they're the bank. Because they got to understand they're the bank. They're providing the financing, the credit. Now, one way they can go, the fastest way you can go, is you send out a notice of forfeiture. That's a 30-day notice. And it indicates to the buyer, essentially, that if you don't bring the land contract current, I'm going to declare it forfeited. Once that period of time's run, then the seller's got to make a decision. How do I want to take this property back? And the fastest way to take it back is through the forfeiture process. It has some limitations. It's swift. As legal proceedings go, nothing's swift, but it's as fast as they get. But you give up certain rights. What happens in the forfeiture process is you file an action in the district court. That's the lower court of lesser jurisdiction. Not the federal district court, but the state district court. They are supposed to arrange a hearing within 15 days. Seldom happens, but nonetheless, that's what the statute says. You'll get one relatively quickly. Let's assume, for example, that your buyer has missed a couple of payments. You then go to the district court, and the district court determines how much is currently owed on this land contract in arrears. So let's assume that it's $4,000 a month. It's 2 months miss. It's $8,000, and then some interest. What happens is the court will enter a judgment in that amount, and then the buyer, the vendee, has 90 days to bring that contract current. And that is pay the arrearage plus pay what would have been payable during the 90 days, and then you're back to go. The contract's current again. All right? If they don't pay it in the 90 days, you get the property back. That's it. I mean your seller does. You're done with the buyer. They may owe you money. You're not going to get any money. The house may now be worth $130,000. You sold it to them for $160,000. Doesn't matter. No deficiency. You get the speed. You get the speed, but you trade off any additional liability, any additional collection of compensation. I must tell you, in most instances, sellers will go this route. They'll go this route because there's a reason why the buyer vendee isn't paying them. They got no money. Okay. Now, alternatively, the seller could say no, because in the 80s, there were certain people who I thought were professionals at making payments 3 or 4 months, then not make payments for 2 or 3 months. Then you'd send the notice of forfeiture. You'd take them to the district court. They would do their money management. They would wait to the 89th day for the writ of restitution issues. They'd pay for a few months, then they'd stop again, and they just do this endlessly. There were people who did this 4 and 5 times on, before the seller finally says, I'm not doing this anymore. All right, so they can opt for something that brings it to an end, but it takes longer. Now you're going to trade greater liability for slower speed, and that is they commence an action for foreclosure in the circuit court. You cannot foreclose a land contract by advertisement like they're doing with residential homes now. You can't do that. You've got to go to the circuit court. And there's a statute that says, even if there's no question, I filed the complaint May 1, they file the answer on May 21st. There's no defense. They just haven't paid. I am allowed to accelerate the entire debt, just like a mortgage. I claim the entire balance is owed. Nonetheless, the statute says I can't have a judgment of foreclosure for 6 months. So think about it. I file, the earliest I can get a judgment is 6 months. I got a 6-month redemption period. I've got to publish. I mean, really, you could tell a seller, if we go into foreclosure, we can sue for the entire amount. They'd have to pay it off to keep you from getting it. If there's a foreclosure sale or deficiency, you can get the deficiency from them personally, assuming they've got any money, but the process takes about 2 years. And in the meantime, there's property taxes due in this property for 2 years. And in the meantime, if you had an underlying mortgage, the payments still need to be made on that. So that's why on land contracts, you rarely, if ever, see a judicial foreclosure of a residential land contract. I don't remember ever doing one. Certainly did it for commercial buildings, but never for residential. It just doesn't make any sense. They live there for essentially 2 years and pay nothing. Okay. I'm not here to discourage the use of land contracts. I just want everybody to understand, what they're about. And we used them in the 80s because we were desperate to have some way to sell and purchase property in this state in that situation. Okay. All right, you're putting this person in possession of the property. We know that to get them out of there, it would take at least 4 months. It may take 2 years. So what do we want to cover? First of all, we want to make sure they insure the property. And that's if you look at paragraph 4, and I consider that a neutral paragraph. You want to make sure, if you're the seller or you're representing the seller, that the buyer buys the appropriate insurance, okay, the property and casualty, case of a fire, case of anything, and that your seller be listed as an additional insured. Okay, so if something happens and the house burns down, there's not going to be a lot of incentive for the buyer to do anything to keep paying a land contract if the house that they had burned down and they've got no insurance proceeds. So you want to make sure that if you're the seller, that you have the option of either taking the proceeds or giving them to have the buyer, and the buyer rebuilds the house. Okay, so yes, sir. Well, if you can't say anything, there you go.
Just to jump back to foreclosure, as far as who would determine? I mean, does the seller determine which way they go, whether it's notice of foreclosure or judicial foreclosure, or is that outlined in the contract?
You cannot do foreclosure by advertisement for a land contract. What you're saying is, who makes the decision, the seller, to forfeit the land contract, get the property back, or get the land contract paid current, or foreclose, go after the entire amount, and take a deficiency. All right. They really need to sit down with two things. I mean, they need to sit down with a lawyer who understands what the law is, and there's about 9 of them in the state right now, and there'll be more. And then also the practicality of the thing. I mean, it makes no sense whatsoever to engage in 2-year foreclosure process in the circuit court to get a deficiency judgment against someone who's got no money. Weighing that against them being in the house for 2 years, knowing they're going to lose it, which means you're probably going to find it in not the greatest state of repair, assuming the copper and the furnace is still there.
But it doesn't have to be in the land contract how you would treat that.
No, actually, what is done, and we're getting kind of ahead of ourselves, but that's okay because we've got to get there anyway. If you look at paragraphs 10 and 11, 10 really sets up the forfeiture proceeding, but 11 gives the seller the out to do whatever remedies available to them. I mean, alternatively, they might choose not to forfeit the land contract, not to foreclose, but to sue the buyer for breach of contract. Okay, and forget the real estate. And how could that happen? Well, there's a case that came down in the 80s. The name of the case it was Gruskin versus Fisher, and that was a case where they ended up suing on the contract. Because what had happened was this. The seller had sold an apartment building on land contract to a buyer in Detroit. And the seller moved to Florida, and the seller all of a sudden didn't receive any more payments. So he sent a notice of forfeiture, as required by law, to the buyer. The buyer said, good deal, send him a quitclaim deed. You want a forfeiture? By golly, I'll give you one. Well, that caused the seller to come up to Detroit from Florida, and you know what? There was no apartment house there anymore. It had been torn down. So, what this whole legal battle was about was the seller bound by one